Welcome back to Google Class. Okay, all of you, how are you? Are you right? Okay, last class we discussed about same Transfer of Property Act only. Today also I am taking same subject. So, and last calls also we studied rights and liabilities of the mortgagee, section 67 to section 77. Okay, and last video section 72. Okay, we discussed. So in this video I am going to discuss with section 73 of section 73 of Transfer of Property Act. Okay, section 73 of Transfer of Property Act. Okay, so TP Act 1882. Here section 73 explain right to proceeds of revenue sale or compensation on acquisition. when acquisition is coming, that time what are the compensation received from the mortgagor or any government official at the time of acquisition. Okay, so here where the mortgaged property or any part thereof or any interest therein is sold owing to failure to pay arrears of revenue or other charges of public nature or rent due in respect of such property, and such failure did not arise from any default of the mortgagee, the mortgagee shall be entitled to claim payment of the mortgage money in the whole or in part out of any surplus of the sale proceeds remaining after payment of the arrears and all charges and deductions directed by law. And second point, when the mortgaged property or any part thereof or any interest therein is acquired under the Land Acquisition Act 1894, one of 1894, or any other enactment of the time being in force providing for the compulsory acquisition of immovable property, the mortgagee shall be entitled to claim payment of the mortgage money in whole or in part out of the amount due to the mortgagor as compensation. Number third point, such claims shall prevail against all other claims except those of prior encumbrances and may be enforced notwithstanding that the principal money on the mortgage has not become due. Okay, in this sentence I just wanted to one comments. The one doctrine is available based on the section 73 of the TP Act. That doctrine name is doctrine of substituted security. Substituted mean instead of. Okay, instead of substituted security. This 73 section is a particular application of the doctrine of substituted securities. The principle underlying the doctrine is that a mortgagee is entitled not only to the mortgaged property but also to anything that may be substituted for it. If through no fault of the mortgagee the mortgaged property assumes a new form, the security is not destroyed. it shifts and attaches to the subject of the mortgage in the new form. A mortgaged house was pulled down and the materials were used by the mortgagors representatives in interest for the construction of another building. It was held that the mortgage attached to the property in the converted state, that is, to the building in the construction of which the material of the mortgaged house were utilized. The doctrine of substituted security is recognized by the Transfer of Property Act. Okay, the two following ways. Number one, the revenue sales. Number two, proceedings concerning land acquisition. First we'll see revenue sale. Okay, the revenue sale, if the property is sold free from encumbrances for arrears of revenue, the mortgagee's rights are transferred from the property to the balance of the sale proceeds, which remains after satisfying the government's dues. Okay, the mortgagee may sue or file for the satisfaction of his debt out of the surplus sale proceeds. The time within which such a suit should be brought is the same as is permitted for suit to recovery money charged on the original mortgage estate. Okay, section 73 does not apply if the sale is subject to encumbrances. Okay, in one famous case, Pandalamal case, what it was pointed out that section 73 from its very language can apply only to sales in which property is sold free of all encumbrances. Okay, this is what saying that Pattammal case. Number two, the proceedings concerning land acquisition. This is another doctrine of substituted security. Second point, the compensation money in land acquisition proceeding is treated as the substituted security. The doctrine of substituted security is supplied in the following cases. How it will be? Number one, judicial sales. This is also one method. Number two, mortgage by co-owner. Two types. So the doctrine, however, cannot be applied to case where altogether different and distinct items are allotted. Thus, where notwithstanding the acquisition by municipality of a portion of the property and its substitution by distinct plot as compensation to the owner, degree is passed. Degree means court order, finality of the case from the civil court. So degree is passed purporting to create a charge over the entire property, making no mention of the substituted property, and the entire property is proclaimed for sale and purchased in execution by the degree holder. Okay, execution by the degree holder, EP cases. Based on this EP cases, who is the degree holder? Okay, who is the petitioner? Okay, so the sale certificate, not only petitioner, who is the main person. Degree holder means in favor of the judgment. Who is the person in favor of that particular case was given by final judgment. Okay, so execution by the degree holder. The sale certificate making no reference to the substituted property. Neither section 73 in terms nor the principle of substituted security is applicable, and the degree holder and action purchaser is not entitled to claim any title to the substituted property. Okay, this is called doctrine of substituted security. Okay, okay, this session is over. We'll meet you again next video. Okay, take care, bye.